Okay, thanks for joining us for this edition of Unboxing the Law. I'm Professor Felix Wu. For those of you who don't know me, I teach primarily privacy law, internet law, and trademark law. And today we're going to talk about the recent Barr versus AAPC decision that came out of the Supreme Court last week. And that raises interesting issues about the intersection of privacy and First Amendment law in particular, and about a couple of questions within First Amendment law about the distinctions between political and commercial speech. So I'm going to talk a little bit about the case, talk a little bit about the different opinions in the case, which are rather complicated for reasons that I'll describe as I get there, and I'll talk a little bit about, my own perspectives on what I think is, going on here and where this might lead, and then we'll open into questions and discussions, in the ways that I'll describe in a moment. I'm happy to also just hear your own thoughts on things like what's your feeling about political robocalls, one way or another, which you could imagine you'd get a lot more of if this case had come out the other way. So what I'm going to actually do is to have you raise hands when we get to the question and answer portion. You can, there's few enough of us here that if you raise your hand on screen, I'll see you that way, or raise your hand using the raise hand feature. You can also throw questions in the chat if you're having difficulty with the raise hands, and I'll try to monitor that as well. But I find it easier if you just use the raising hands as the primary method of asking questions. Okay, I'm going to go ahead and share my screen here to show a few slides. And one sec while I get the rest of these set up. All right. So what is this case about? This case is about the Telephone Consumer Protection Act, which was passed in 1991, which has actually a lot of parts to it. And it's only one particular piece of the Telephone Consumer Protection Act that's at issue in this particular case. But among other things, the TCPA makes it unlawful to make any call other than a call for emergency purposes or with prior express consent using any automatic telephone dialing system or an artificial or pre-recorded voice. Now, I'll just pause for a moment and note this particular case is not about the automatic telephone dialing system part. Instead, it's about the artificial or pre-recorded voice part, right? That's the idea of a robocall, where you, have something pre-recorded, or often like maybe even literally a robocall, like robotically generated message, where there's not even a person who had to actually make the recording, right? And you take that artificial or pre-recorded voice and you use that to make your call. So those robocalls are what this case is about, but I just want to note that actually there's been a lot of disagreement in the lower courts about what counts as an automatic telephone dialing system, and whether and to what extent some form of mass dialing counts as the use of an automatic telephone dialing system, when what ends up happening is that you actually end up getting a real person at the other end, right? Meaning the person calling you is a real person, not a robot, not some sort of artificial or pre-recorded voice, but they're doing it in some kind of automated way that allows for mass dialing. So the circuit courts have split on what counts as an automatic telephone dialing system, and actually the Supreme Court just granted cert in this upcoming term to decide that issue about what counts as an ATDS. Okay, but this case that they decided in this previous term was not about that. Instead, was about the use of these artificial or pre-recorded voice. And you'll see, right, unless it's made for emergency purposes or with prior express consent, you're prohibited from making any call using an artificial or pre-recorded voice to a cell number. Okay, so you see there's a bunch of ors in part 3 there, other things, mobile radio service, whatever, any service for which the called party is charged for the call. But the key one here is just that it prohibits all, I'll call it robocalls, to cell phones. All right, and that's how the statute was written in 1991. Now, what happened next was that in 2015, Congress passed an amendment to the TCPA adding this exception, right? Left the rest of it identically the same, but added this exception, saying unless such call is made solely to collect a debt owed to or guaranteed by the United States. Okay, so this is what the court describes as the government debt exception. Now, just to be clear, throughout, right, debt collectors are one of the biggest users of various kinds of calls of all sorts, right? Whether automated calls or artificial calls or pre-recorded calls. So debt collectors were a big category of entities that were making these kinds of calls. But in 2015, the Congress basically decided that that those kinds of debt collection calls were okay, if so long as the debt being collected was a debt owed to or guaranteed by the United States, which, by the way, covers a lot of debts, right? Both because the government backs a lot of mortgages, and because the government also backs a lot of student loans. And so between those two things, there are actually a lot of these kinds of government debts. And notice, it's not that the call needs to come from the government, right? So long as the call is being made to collect a debt that is owed to or guaranteed by the United States, then it's permissible to use a robocall, at least under this 2015 amendment, right? And the basic concept here was, well, the government just wanted to make it more efficient to actually collect these debts, because at the end of the day, if the debt is owed to or guaranteed by the US government and you can't collect on it, it's the government that ends up, losing money. And so just purely from a monetary perspective, the idea is, we want to allow these calls so that these kinds of debts, at least, are more efficiently collected, and the U.S. government makes more money. All right. So that's the government debt exception that was added in 2015, and that's the exception that has now been struck down in this case, Barr versus AAPC. Now, here's the thing: it's not debt collectors who actually challenged this law. Okay, so one could imagine this law being challenged, let's say, by debt collectors who are collecting private debts and not government debts, right? But those were not the people who challenged the law. Instead, the people who challenged the law were various kinds of political organizations that actually wanted to be able to place robocalls for political purposes. Okay, and because they're prohibited from doing so, and obviously they're not covered by the government debt exception, right? And their main argument was, look, even if the law might have been constitutional before, now that you're adding this exception, you've created an unconstitutionality to the law as a whole, including, and maybe particularly as applied to us, as applied to those who want to be able to make robocalls for political purposes, right? And the benefit, I guess, or reason why you might have a political entity trying to make this argument is that political speech has long been understood to be kind of the most protected thing under the First Amendment, right? If you're going to protect anything, you're going to want to protect political speech. And so the argument here is, look, if you're going to provide any exceptions, the exceptions should first be for political speech rather than for anything else, right? And so the fact that you're going around providing exceptions for other things calls into question, like, well, why didn't you provide an exception for us, for political speech, for the thing which the First Amendment most strongly protects, right? So that was their argument. Now, in a way they won, and in a way they lost. So what the Supreme Court decided was, yeah, they're right, this law violates the First Amendment. But what the Supreme Court also decided was the fix for it is to strike the government debt exception, right? To strike the exception for collecting government debts. The end result being that the political organizations are still prohibited from making robocalls, just as they were before the 2015 exception, and just as they were, before this case and this decision. The only difference now is that now, for those trying to collect government debts, they can no longer use robocalls to collect government debts. Okay, and it was a very split opinion. In fact, there was no single majority opinion. So as I'll show in a moment, so there was no opinion that actually garnered 5 votes. And in fact, even the thing that you might describe as the plurality opinion, in some sense, only barely garnered 4 votes. Because the portion of it that was joined by 4 justices was also, in some sense, opposed by another 4 justices. So there's like barely any analysis in here, which is in fact which is in fact a binding precedent going forward. Now, there's various results, I guess, that are that are going to be true going forward. But the opinions are very split. So the summary from the case itself was that 6 members of the court agreed that the government debt that the TCPA with the government debt exception violates the First Amendment. But then 7 members of the court also agreed that that exception could be severed, removed, right, from the rest of the statute, leaving the rest of the statute intact. And as the court says, the result is that the plaintiffs still may not make political robocalls to cell phones, but at least now their speech is being treated equally with debt collection speech. Okay, so I'll come back to this concept of equal treatment in a moment. First, let's just talk a little bit about the various opinions in the case. Okay, starting with what I guess I'll call the main opinion here, which is Justice Kavanaugh's opinion. And you'll see that opinion was joined by Chief Justice Roberts, Justice Alito, and joined as to the First Amendment analysis, but not the severability analysis, by Justice Thomas. That's why I've got Thomas off to one side here. Okay, so it's like kind of 3+1 here. And for this set of 4 justices, the first step was whether or not the robocall restriction with the government debt exception is content-based. And they say yes. Well, they say yes because, look, you're distinguishing depending on the content of the call, right? If the call is political speech, no robocall. If the call is a call to collect government debts, then you're allowed to use a robocall, right? And so the court says that is just on its face a distinction you're making depending on the contents of the call. So that's a content-based distinction. And any kind of content-based distinction, that's, next step, step 2, right? The court says is subject to strict scrutiny. And once you invoke strict scrutiny, right, which is the highest level of scrutiny under the First Amendment, the most stringent possible standard for the government to try to satisfy, it's really, really hard for the government to satisfy that standard, right? Just as a matter of precedent and the like, very, very, very few cases have been able to get past strict scrutiny, particularly at the Supreme Court level. And indeed, in this case, the government conceded that it could not satisfy strict scrutiny, if that's where the court got to. All right, so that's the first part of the main opinion, right? The part joined by these 4 justices. But then, these 4 minus Thomas, right? So just the first 3 said, but we're just going to apply ordinary or general severability principles, and those principles dictate that we can just invalidate, or that we ought to invalidate just the exception and leave the remainder of the statute. And the basic idea here is that there's other indications in the statute that severability is what Congress would have wanted. And moreover, just think about the history, right? I mean, you had this statute existing for so long until the 2015 amendment. It seems pretty clear then that the right idea here is that, well, just back out of it then, right? You had all these years without the government debt exception, and Congress was just fine with it. It makes sense then that they would want to back that out and get back to what the statute looked like before. Okay, so that was both the First Amendment analysis and the severability analysis in the main opinion. Next, I'm going to turn to Breyer's opinion. All the other opinions are styled as some form of concurrence/dissent or something of that sort. But this one was one in which Justice Breyer took a totally different approach. Right? Justice Breyer says, look, strict scrutiny is not the right thing to do here, right? Strict scrutiny is the kind of thing we want to do when the government is like directly prohibiting political speech or doing various kinds of things that fall in the core of what the First Amendment is meant to protect. And so what he does is he focuses on just the government debt exception. And he says, look, if this is the thing that's suddenly making the whole law unconstitutional, we shouldn't be worrying about this thing too much, right? The only thing we've done here is to change something about the way in which debts are collected. And how debts are collected is really not anything the First Amendment really cares about, right? How debts are collected is just like pure economics. And that pure economics is not the sort of thing that the First Amendment should get involved in. And in particular, we shouldn't be somehow applying strict scrutiny to stuff which is mere commercial regulation, okay? On the other hand, he says, well, look, but on the other hand, I'm not willing to go all the way down to just rational basis test, right? The basic, the easiest form of scrutiny is the one in which the government needs to show only a rational basis for the regulation. That's the one that applies like if speech is not at issue at all. Just like, you know, what is the baseline level of plausibility that the government needs to meet, and it's a really, really low baseline. Okay, so Justice Breyer says, well, I'm not willing to apply that really, really low baseline. Instead, I'm going to apply a kind of form of intermediate scrutiny, right? Something that's not as high as strict scrutiny, not as low as rational basis review, something in between. Something in between that basically is going to say, well, is there a good enough reason for doing what you're doing here? Does it not impinge upon too much? And he basically says, yeah, sure, right? Because the good enough reason here is that the government, the U.S. government, wants to make it easier to collect U.S. government debts in order to protect the public fisc. And that's a perfectly good reason. And we're not doing such terrible things here because, after all, it'll add some robocalls, but it doesn't just open up the entire world. And it's a perfectly reasonable approach to make government debt collection a little bit more efficient and not disturb too many other things. So he says it survives intermediate scrutiny. But then he says, but since a majority of the court has decided otherwise, I at least agree that the provision is severable, and so therefore, concurs with the severability portion of the main opinion. So that's 3 additional justices, right? I'll note 3 traditionally liberal justices here: Breyer, Ginsburg, and Kagan. And you've got the 4th, traditionally liberal Justice Sotomayor, agreeing with the First Amendment level of scrutiny. In other words, namely that we should apply intermediate scrutiny and not strict scrutiny, but disagreeing about how the analysis comes out, right? So she says, I agree with Breyer that intermediate scrutiny is the right level, but I actually think that it fails intermediate scrutiny because the idea is like, well, it's only barely a justification that you want to collect more money to say, therefore, we're going to allow you to infringe on people's privacy in this way. And if you're going to allow it for making money, why wouldn't you allow it for like political speech or other sorts of things, right? There are all sorts of good reasons for potentially allowing robocalls. And this seems like just barely a good reason for allowing a robocall. And therefore, Justice Sotomayor says, I think intermediate scrutiny is right, but I don't think it meets intermediate scrutiny. And then, by the way, she also thinks the provision is severable, in the end. So hers is in that sense a concurrence as well. Finally, there's Justice Gorsuch's opinion. Now, Justice Gorsuch says a couple of different things. Now, again, I've got these two, somewhat separated. So Justice Gorsuch has a completely different view about the right way to proceed with the First Amendment analysis. That's just him alone. And then he also has a disagreement about the severability analysis. That's both him and Justice Thomas. So on the First Amendment part, he says, I agree it violates the First Amendment, but I don't think that it's for the same reasons that the main opinion is describing. He's less worried about this idea that there's some real, about the fact that political speech and debt collection is being treated differently, right? He doesn't see so much as the issue here about them being different. What he's really concerned about is that you've got these people who are trying to speak politically, and you're stopping them from doing so. And your justification, namely to protect privacy, is not that great of a justification, given the fact that you're going to allow the debt collectors to make these, or the government debt collectors to make these robocalls. So his focus is really on the actual plaintiffs themselves, the actual people trying to make political robocalls. And he says, look, maybe there's a good reason to stop them from doing so, but you haven't really come up with a good enough reason. And for that reason, the law violates the First Amendment. And moreover, in some sense, because that's the reason, the right remedy here is not to sever the government debt exception part, but to prohibit the government from applying this law to these political speakers, right? So effectively, we should kind of create a new exception, right? One that's essentially mandated by the First Amendment rather than in the law itself. And the new exception should be for political speech, okay? So in that sense, there should be then an injunction prohibiting the government from enforcing the TCPA against political speakers. Okay, and that part was joined by both him and Justice Gorsuch. By him and Justice Thomas, right? So the two of them together have that view. Okay, so let me give you a few quick thoughts, and then I'll open it to questions and discussion. So there's a way in which, like, if you read this opinion kind of from top to bottom, the main opinion, like, is somehow, it makes it seem like this whole thing is just obvious. Like how could you possibly think anything other than what we are saying, right? So how could you think anything other than that this is a content-based distinction that's being made, right? And once it's content-based, clearly strict scrutiny applies, and therefore clearly violates the First Amendment. And once you've got a First Amendment violation, you just apply ordinary severability principles, and like these are just ordinary principles all the way down, right? This is just ordinary content discrimination, and the ordinary way we deal with content discrimination, and the ordinary way we deal with a violation of the First Amendment. And there's just no other possible way of analyzing this case. All right? What I want to suggest is, in a way, I actually think this main opinion is the least convincing out of the various opinions. I'm actually still a little bit torn between Justice Breyer's opinion and Justice Gorsuch's opinion, even though they come out in diametrically opposite ways. And I'll describe why in a moment. In the end, I think I'm still more with Breyer than Gorsuch, but in a way, both of what they said is actually more compatible with each other in some sort of surprising way than either of them is with this main opinion. See, to me, the problem with the main opinion is that it doesn't seem like it's connected to any kind of First Amendment values. Like, what First Amendment values are being served by this particular form of the analysis? At best, I think you could say there's a kind of formal equality value that drives this main opinion here. But it's not at all clear why formal equality is such an important thing in the First Amendment space. And when I say formal equality, I mean, you know, the fact that my speech is being treated perfectly equally to your speech, right? Like, what I really care about in my speech is my speech, like whether or not I get to do it or say it or whatever. It's not as clear to me that just that we should somehow, that so long as we equalize, you know, that we've achieved something in the speech context, all right? Might be, for example, quite different in the race context, although in that context too, there's a lot of dispute in anti-discrimination law about whether formal equality is the right way to think about racial discrimination or not, or whether instead we should be thinking about it in terms of anti-subordination, okay? So I've said a lot, there's a lot packed into what I just said there, but I just want to flag that as in a different direction. Okay, so, but I think whatever you think about that debate with respect to racial discrimination, I think that it's harder to make the argument that formal equality is a real First Amendment value in the First Amendment context. And so there's a way in which each of the other opinions is really focused on these two ends, right? Either the commercial speakers or the political speakers, rather than worrying about how they compare to each other. Justice Breyer's opinion is really focused on the commercial speakers, on these debt collectors generally. And as far as he's concerned, it's like, okay, so you've distinguished between government debts and other debts. Who cares? Or at least the First Amendment doesn't care, right? The First Amendment shouldn't have anything to say about like what kinds of debts you're allowed to do what with. Because at the end of the day, the people who care about the debts are the debt collectors, right? And in this case, the people who are the recipients of these calls don't want either one. And so there's no really like First Amendment thing going on here, right? The debt collectors just want their money. And the people who are listening, the listeners, right? The listeners to the call have no interest in getting these calls whatsoever. So who's exactly trying to speak, right? There's not really any speech at issue here. There is in a formal sense, but not really. What's really going on is that, you know, you've got debt collectors. And now I've written more about this in other contexts in which I've suggested that, you know, for commercial speech in particular, and I would say debt collection speech is definitely one of these things, the only entity that matters from a First Amendment perspective is the recipient of the speech and not the actual speaker. And in this case, since the recipients would rather you leave them alone, it is in that sense that there's basically no First Amendment issue at stake whatsoever. In my view, that actually makes, if you just focus on the debt collectors, that makes it such that even intermediate scrutiny is too strong. I actually would go with just rational basis review for what you can do with debt collector speech. And so in that sense, I actually disagree with Justice Sotomayor and like worrying about, sort of the intermediate scrutiny aspect here. At least, again, if you just focus on the debt collectors alone. Justice Gorsuch, though, basically goes the other way. He says, I don't really care about the debt collectors. The people I really care about are the political entities that want to engage in political speech. And so if it's a problem with respect to them, right? And if it's a problem with respect to them, we should do something for them, right? We should make it so that they can actually make robocalls if they want to. And if you think about it, the argument here is, look, if they can't make robocalls, they can't get their message out as efficiently as they otherwise could. Okay, and you as the recipient may hate robocalls, right? But there is real value in political entities of whatever stripe being able to get their message out, right? That's a real kind of First Amendment value. And how that value balanced against, ordinary people's interest in not getting these calls whatsoever just because they want to be left alone, right? That's a much harder thing to figure out. Whereas in the commercial context, I say, look, it's only the people who are getting the calls that matter. In the political context, it's much harder to say. And that's why I actually think, there's a way in which there's something to Gorsuch's opinion. There's a way in which one could imagine that one sensible thing to do here going forward is to say, look, we should not be using the TCPA to cover political speech. And there's precedent for this. The Can-Spam Act, which applies to unwanted emails, for example, only applies to commercial emails, not to non-commercial ones. And so you can imagine distinguishing in these kinds of cases between political and commercial speech, saying, look, I get it, the political stuff is annoying people, but on the other hand, there are real First Amendment, interests at stake here, and we're going to separate those out. And then on the flip side, whatever the government wants to do about the debt collectors or other people who are engaged in commercial speech, they can do whatever the heck they want. The government can do whatever the heck they want in regulating these entities, and the First Amendment should have nothing to do with it. So that's the sense in which, one could imagine actually a version of this that is actually a combination of Gorsuch and Breyer and is totally the opposite of the approach taken by Kavanaugh's opinion. All right. So that's some thoughts on the opinion and how one might think about it. Happy to take questions, comments. It doesn't even have to be a question. I'm just be curious to hear if you're convinced or not about my perspective. And if nothing else, I'd love to hear your own thoughts about whether or not you think the First Amendment should ultimately protect political robocalls or not. Thoughts, questions? Yeah, Jake.
I don't know. I'm just trying to reconcile this in real time. I hear the First Amendment concern as real, but I also so strongly hate robocalls and just see it as
I know, right?
dangerous and intrusive and privacy violating technology that I feel like there should be. I was actually surprised. So the Can-Spam Act that you mentioned, so you can get spam emails for political purposes?
Just to be clear, so the Can-Spam Act like barely does anything in the sense that it does not prohibit it. It doesn't even prohibit unwanted commercial emails. It only requires that those commercial emails be truthful in various ways. They have to truthfully say who they're coming from, and they have to give you an opt-out option. But they can send you at least the first one, at least before you opt out. They can send it to you even if you kind of don't want it or something like that, right? So it's very mild restrictions anyway. But yes, whatever the restrictions are under the Can-Spam Act, they apply only to commercial emails and not to non-commercial ones.
Isn't there also a phone number opt-out list for robocalls? Is that related to the TCPA?
It's a different part. The do not call list is another part of the TCPA. The do not call list similarly applies only to commercial calls, not to non-commercial ones. Which, if you think about it, makes sense, right? Because I don't even know, like, what would it even mean to have a do not call list for would it mean like if I'm on the list, right, that like, that you can't call me anymore, right? I mean, without like my prior express permission or something. I don't know, right? It would be a little bit weird. So yeah, no, so the do not call portion is only for commercial calls as well.
And it only applies to calls, not text messages, right? Because I know for political campaigns, I get random texts sometimes from campaigns that I have no affiliation with.
Yeah, so so the TCPA in general actually has been interpreted by the FCC to apply to texts as well as phone calls, and actually a lot of the debate around around this provision, for example, around like using an automatic telephone dialing system, has actually involved companies sending text to cell phones, right? Because if you're using an automatic telephone dialing system and you're using it to send a text, right, then that's covered here by this. Now, the artificial pre-recorded voice part, of course, can't really apply to a text because there's no voice involved. But this part has been held to apply to as well. So so then the big question, as I said at the beginning, is what counts as an ATDS, and so there the courts have split, and we'll find out more soon.
So what you mentioned in regards to the text messages, I'm just thinking, I used to work as a software engineer. I used Twilio's API all the time to send text messages, but I guess in those instances, the user would have consented to receiving those messages, so that would have been fine.
Right. So definitely, anything you do with prior express consent is fine, right? And so so that's always fine. The real problem is what happens if you don't have that prior express consent. And also there's, there are various other ways in which, frankly, companies get tripped up here. So what happens if the phone number gets reassigned? And so that's one problem, right? Because you had consent of the person whose phone number it was, but you no longer actually have the consent of the called party, right? Because you're now calling a party who's a different party from the one that you got the consent from, right? So that's one problem here. And then other times, there's also like the withdrawal of consent. Somebody says, I don't want to get these things anymore. And for whatever reason on the back end, the company fails to take them off the list, or sometimes they're really just acting badly and just leaving them on the list anyway. So there's all sorts of ways in which this can go badly for companies. This is a big deal because I haven't shown it here, but it has a private cause of action with substantial statutory damages. And so what you're getting in these contexts are class action lawsuits. And particularly if a company has had some sort of large scale problem with the way in which they've sent out either either text messages or auto dial, automatic calls in one sort or another. The allegations in these contexts often are like that, millions of unlawful calls have been made, and it's $1,000 per call. So you're talking about like class action lawsuits that claim damages in the billions.
Wow.
Yeah.
Last question, and then I'll
Sure.
now. The first thing that came to mind with the TCPA was I think it was in 2018, 2 years ago, Google announced something called Google Duplex, which was like an AI assistant that can make phone calls on your behalf and like make restaurant reservations and stuff like that. Is that currently illegal under the TCPA?
Well, that would depend on whether it counts as an automatic telephone dialing system, and the answer to that is almost surely no. Oh, I guess the artificial pre-recorded voice
Right.
part, because it does like use an artificial voice, right?
Right.
For those calls. Yeah. I mean, I guess to the extent to which you did it to a cell number, it would be a problem. But if you do it to a business, it's not going to be that's not right. I mean, it's not going to be a cell number generally.
Right. It would be dialing to a business placing a reservation or something.
Yeah, and nothing in here prohibits the use of any of this stuff to call a business.
Got it. Okay.
Yeah.
Cool. Thank you.
You're okay on that. Other thoughts, questions?
See, there's something in the chat.
Oh, sorry. Should open that up. Okay, yes, looking at it now. Yeah, okay, so the question in the chat was, can I say more about the aspects of the call recipient's right to privacy? How does this case affect the weight of the right and how it has developed, starting from Griswold or other cases, and the question of balancing privacy against First Amendment rights. Great, so so, you know, as Jake was describing, right? You know, he thinks political speech is important, but he also hates getting these robocalls, right? And it's a kind of privacy violation. Now, what's interesting here is that the kind of privacy violation we're talking about is a very specific kind, right? There are a lot of things which we think of as privacy violations, and a lot of ways in which there are complicated questions about how privacy fits with the First Amendment. In what I'll call a kind of paradigmatic version of the privacy versus First Amendment problem, the problem is that you want to talk about a person, and that person doesn't want to be talked about, right? And so there's an idea with like, okay, I want to be able to say something about this person. I want to be able to like say that they are, you know, COVID positive, let's say, right? And that's speech on my part. I want to be able to communicate it to other people, tell other people. But that person will find it to be an invasion of their privacy to have other people being told that they're COVID positive, right? That's the classic form of privacy versus First Amendment, right? I have something to say, and I want to talk about a person who doesn't want to be talked about. This kind of case, the TCPA cases are different, right? Because these cases are about people who don't want to be talked to, rather than people who don't want to be talked about, right? And so that you know, feels somewhat different in terms of trying to understand like what kind of a privacy right is that? The right to not be talked to. Now, in a way, there's a long pedigree to this concept of privacy. When Warren and Brandeis wrote this, you know, the article about the right to privacy in 1890, they conceptualized it as a right to be let alone. And that like right to be let alone is a lot of what people feel like with this robocall stuff, right? They're like, you know, you're bothering me. Like, I don't want you to bother me. And it's a real bother that you're bothering me, okay? But what's tricky about it is trying to figure out like, well, but what exactly is the bother, right? Or what exactly is the thing? Like, in a way, it's almost more hassle than it necessarily is, you know, I don't know, like a notion of information privacy, right? It's not really about the information, it's about the hassle involved. And the thing is, if you think about it, there are a lot of things in the world that create hassle. And it's not exactly clear how to think about this one or the status of this one, right? The status of being bothered and how to think about it. And so that's why, in effect, like a lot of the other cases that were about the right to privacy or the way to the right to privacy are often about something different, as compared to the you know, what's going on in a case like this. Nevertheless, most people think that, but you know, as I said, going back to Warren and Brandeis, most people think it really is a problem, right? It really is a problem to be bothered, to be intruded upon, right? It's like disruptive in a certain way, and that disruption is you know, something you should have a right to be able to prevent, right? Think of it a little bit like, you know, preventing people from, you know, from like, think about it as like akin to sort of assault and battery or something, right? And people from like, you know, touching you or threatening to touch you. It's like they're invading, you know, your bodily space in that context. And in this context, they're invading your kind of mental space, your peace of mind, right? Your ability to kind of go about your life without having that kind of intrusion, that kind of interruption. And I think what's a really tricky question here is, how strong is that right? How strong is your right to not be intruded upon? Because like I said, there are lots of contexts in which we don't think you have that kind of absolute right not to be intruded upon. There are lots of ways in which we think other people trying to talk to you maybe should get a shot at talking to you, right? That their ability to communicate, get their message across is an important one. And at least in some circumstances, we should think of that as being strong enough to overcome, you know, or to outweigh, I suppose, you know, your interest in not being talked to. Anyway, so that's not exactly like an answer, in part because the courts don't have an answer to this problem of how to weigh or balance or fit together these two things. But I do think it, you know, for all the reasons suggested, does raise these important and interesting questions about how to conceptualize privacy in this context. Anyone else? In chat or otherwise? All right. I don't think I see any. I'm scanning both the windows and the participant window and the chat, and I don't see anything more. Well, great. Thanks for joining. If anyone has further thoughts or something or further questions, feel free to just shoot me an email, and I'm happy to discuss more.
Thank you.
Thank you.
Have a good rest of your day.
Thank you.